I'm Troy Kirby with a quick look at the 2022 Washington State legislative session. The Senate Labor, Commerce, and Tribal Affairs Committee heard public testimony on Engrossed Substitute House Bill 1795, which would prohibit non-disclosure provisions regarding illegal acts.
It really comes on some ideas I've received from constituents in my area and other people in our community, building on the great work the legislature done after the 2017 Me Too movement that brought to light horrific incidents of sexual assault and harassment in the workplace that have been persisting for decades. And we know that one of the main reasons this illegal behavior was able to permeate workplace culture was because victims were silenced by legal paperwork.
Several things here that have concerns within this bill. The first of which is the basis for how you determine whether there is, quote, illegal activity or if it's illegal to do this. It's based on the employee's reasonably believed to be illegal. Testimony in the House was that if an employee made a complaint or filed something, then it must be illegal. That's not the way it works. There's many times when someone disputes something, and when they dispute it, it would actually be found that it's not illegal in some activity. So the standard of how you would determine whether this is a violation and how it's being interpreted by the folks that are going to try to enforce it is that by the mere nature of filing something.
We're here today because for decades, employers have conditioned settlement of illegal workplace conduct claims on silencing victims from talking about how they were mistreated through the use of non-disclosure or non-disparagement provisions, which are known as NDAs. NDAs forbid employees from speaking about their experiences or observations to anyone, ever.
In 2018, we worked with stakeholders on the series of bills, including Senate Bill 5996, that established restrictions on the use of non-disclosure agreements. Section 4 of this bill repeals all of that work and replaces it with new claims of action and ambiguous legal standards.
In my career, I've signed numerous types of confidentiality clauses, and at many workplaces, I face discrimination as a woman, as a single mother, and as a disabled person. I've been retaliated against and experienced and witnessed sexual misconduct. I didn't feel safe to discuss these matters because I didn't understand the legal implications of the documents I'd signed.
NDAs or gag orders consistently benefit the person or entity that has caused the harm and is consistently used against the victim of the harm who is now prevented from sharing their experience, truly addressing their trauma, and openly ensuring that no one else experiences the same harm from the same perpetrator.
As an employment attorney, I represented many clients who suffered from discrimination, harassment, and abuse in the workplace. I'm prevented from talking about the specifics of the cases I worked on because the resolutions are subject to confidentiality, but I can say generally that the misconduct at issue in those cases involved repeated unwanted sexual advances by supervisors, violent sexual assaults at work, blatant discrimination based on race, sex, and disability, and willful wage theft.
Although the language of the bill does not specifically name bullying, it broadens the scope of harmful acts, and it ensures that employees who leave their jobs due to similar unfair practices, also such as sexual harassment and abuse, are the owners of the story and can freely share it.
Thank you for watching the 2022 Washington State legislative session.